New York Education Law 2D. Why do educational agencies need a data protection officer? In 2014, New York State passed Education Law 2D, followed by the adoption of Part 121 regulations in 2020. The purpose behind Ed Law 2D and Part 121 is strengthening data privacy and security in New York State's educational agencies to protect personally identifiable information of students and teacher-principal information as it relates to APPR. Ed Law 2D requires each educational agency to designate a data protection officer to be responsible for the implementation of the policies and procedures required in Ed Law 2D. What is a data protection officer responsible for? The data protection officer will serve as the point of contact for data security and privacy of the educational agency. The complexities of a DPO vary for each educational agency, but they are responsible for the implementation of the policies and procedures required of Ed Law 2D. Let's highlight a few of the DPO responsibilities. DPOs will work with stakeholders to identify where personally identifiable information resides in the district, both physically and virtually. Ensure the district has a signed and posted Parents' Bill of Rights and supplemental information for each contract the district enters into with a third-party contractor that receives PII. DPOs will work with key stakeholders to develop an incident response plan and implement annual data security and privacy training. What is personally identifiable information? Ed Law 2D follows the FERPA definition of personally identifiable information, which includes, but is not limited to, student name, parent names, student ID number or email address, student photos or video of students, student medical information or special education information, other indirect identifiers, information that alone or in combination would allow a reasonable person to identify the student. PII from the student records of an educational agency or records of an educational agency relating to the annual professional performance reviews of teacher principals is protected under Ed Law 2D. Parents' Bill of Rights. What are the required elements? Educational agencies must develop a Parents' Bill of Rights for data privacy and security. Parents' Bill of Rights must be posted on the educational agency's website and be included with and signed for every contract entered with a third-party contractor that receives PII. The Parents' Bill of Rights shall state in clear and plain English that data will not be sold. A student's personally identifiable information cannot be sold or released for any commercial purposes. The right to review a child's record. Parents have the right to inspect and review the complete contents of their child's educational record. Data is protected. State and federal laws protect the confidentiality of personally identifiable information, and safeguards associated with industry standards and best practices must be in place when data is stored or transferred. NIST collected data. A complete list of all student data elements collected by the state is available for public review. Districts must include an appropriate NIST link and NIST mailing address for parents. Breach complaint contact. Parents have the right to have complaints about possible breaches of student data addressed. Districts must include appropriate complaint submission contact information. Supplemental information. Supplemental information for each contact an educational agency enters into with a third-party contractor, where the third-party contractor receives student data or teacher or principal data. Supplemental information. What are the required elements? Educational agencies are required to post the supplemental information for any contract entered into with a third-party contractor that receives PII. Supplemental information may be redacted to the extent necessary to safeguard the data. Supplemental information must include the exclusive purpose for which the student data or teacher or principal data will be used by the third-party contractor as defined in the contract. How the contractor will ensure that the subcontractors, if any, will abide by all the applicable data protection requirements, including but not limited to those outlined in applicable state and federal laws and regulations. The duration of the contract, including the contract's expiration date, and a description of what will happen to the data upon expiration of the contract or other written agreement. If and how a parent, student, eligible student, teacher, or principal may challenge the accuracy of the student data or teacher or principal data that is collected. Where the data will be stored, described in such a manner as to protect data security and the security protections taken to ensure such data will be protected and data security and privacy risks mitigated. Address how the data will be protected using encryption while in motion and at rest. What needs to be included with a third-party contract? Educational agencies must obtain a contract with a third-party contractor that will receive student data or teacher or principal data from an educational agency. Contracts must require the confidentiality of shared protected data be maintained in accordance with the law and the educational agency's policy, ensuring they will not sell PII nor use it for any marketing or commercial purposes. Additionally, the third-party contract must include the educational agency's signed Bill of Rights along with the required supplemental information. What other protections should my district have in place? Educational agencies are required to adopt and publish a data security and privacy policy on the district's website. The data security and privacy policy must align with the National Institute for Standards and Technology framework, the NIST CSF, and be consistent with applicable state and federal laws. The privacy policy must address every use and disclosure of PII by the educational agency must benefit students and the agency. Personally identifiable information will not be included in public reports or other documents. Include all the protections afforded to parents or eligible students where applicable under FERPA and IDEA and the federal regulations implementing such statutes. What are the NIST CSF requirements for an educational agency? The NIST CSF provides educational agencies with a set of cybersecurity activities, desired outcomes, and references that are common across critical infrastructure sectors. Educational agencies will utilize NIST CSF to identify their current profile. What is their target profile? And are there any gaps which will be used in the development of an action plan? Can parents file a complaint about unauthorized release of their child's PII? Educational agencies must establish and communicate to parents, eligible students, and other staff of the procedure to file a complaint about breaches and unauthorized release of student and/or protected teacher or principal data. If a complaint is made, the educational agency must promptly acknowledge receipt, commence an investigation, and take the necessary precautions to protect PII. Educational agencies must provide the finding to the individual who filed the complaint no more than 60 days from receipt. Additionally, Records must be maintained of all complaints and their disposition in accordance with applicable data retention policies. Do we need to provide annual employee training? Education Law 2D requires educational agencies to provide annual data privacy and security awareness training to employees with access to personally identifiable information. Topics to cover would be training on state and federal laws that protect PII, such as Ed Law 2D, FERPA, or COPA. Include general security awareness, such as phishing, ransomware, passwords, and training on the educational agency's policies. Consider developing targeted training based on specific user roles and areas of risk within the educational agency. Additional information.